Hello, ladies and gentlemen, and welcome back to wearefree.tv, the channel that brings you different people from around the world talking about various subjects to do with self-development, the new world, the fifth dimension, aliens, channeling, science, alternative medicine, alternative information, science, common law, free men on the land, and many, many more interesting subjects. I'd like to thank everybody that's donated, highly appreciated. Also, please do join our Telegram group, which is shown below, wearefree.tv, and this is where we post links to every new interview as and when it comes out. So please do join the group, and also make sure you send this video to all of your friends and post it and share it on all of the social media that you are a part of. Thank you very much. And today's interview is a very special interview. Once again, my guest is going to be Mr. Chad Manian, who is a lecturer, researcher, peace activist, common law campaign. The name of the interview is Defeating the Council. We're going to talk about Paul Watson, who managed to defeat the council, and he actually got out of a £37,000 bill, which is pretty impressive. So, hello there, Chad Manian. Welcome back. How are you today?
Be back here.
Sorry, your microphone was off, so welcome back. And how are you once again?
Yes, brilliant. It's lovely to be back here, Michael. Good to be back on line with you.
Excellent to have you. So we have a very, very sophisticated, detailed, professional, high-level interview or show or program today. We're going to talk about we're going to show the letter that Paul Watson sent to the council. I believe it's an absolute piece of art in terms of common law, and we're going to actually go through it, and then you're going to explain to us the logic behind of every single line in the letter. However, before we do that, you want to give us like an introduction to what we're going to talk about. So please go ahead.
So just to introduce the idea, we're talking about council, we're talking about the idea of taxes, and we are discussing the law of the facts versus the legality of the fiction. So normally, bills, taxes, debts, loans, etc., they're affiliated to what we call the straw man, or your fictional identity, which begins through your birth certificate. Now, all of the fees, the fines, the penalties have mainly to do with the straw man, which is addressed to your name in capital. That's at least how it works here in the UK. So any official letter written demanding you have to pay X amount to Mr. Y or Z, essentially that's addressed to the straw man. It's the name in capital letters.
Yeah.
But on the other hand, you are the living, sane and sovereign human man or woman. So why should you be liable to pay? I mean, there's an idea that I'd like to put out there. This Native American chieftain once said, "Why do you need to pay this piece of paper to live on a planet you were born on?" And that's the idea that I'm trying to get back to. Who exactly came up with the idea that said, in order for you to live on a piece of land, you have to first register your details with this body. And basically, you have to end up paying your way through just for the privilege of living there, for having, your garbage removed and all of the other supposed benefits you get. So that's the starting point on which to base the discussion.
Okay. So shall we just jump straight into the letter?
Yeah, I'm happy to.
So I'm showing the letter on the screen right now. And let's start from the top part. We have, it says non-negotiable, and then we have first, last, blah, blah, blah. It's addressed to the council, Cornwall Council, County Hall, and then it says notice for conditional acceptance for summons. So what do I understand that Watson received a summons and now he's replying to their summons and he's conditioning it upon something, yes?
Yeah, that's about right. So usually when you receive a summons, that goes back to something, an idea that I'd like to just introduce called the 12 presumptions of law, the 12 presumptions of court, actually. And what are, first of all, just to give you a little pretext, what are these presumptions? A presumption is a preformed assumption that they have before they even see you, before they become familiar with the facts that you're presenting. A presumption is an idea or an opinion or a belief that they created in their minds. Now, a proof that is unrebutted stands as fact. So any presumption that they form, if you don't rebut it, it essentially means that presumption stands as fact. So in law, this concept of an unrebutted presumption holds the power and position of fact. There's one presumption, which is the fifth presumption of summons, which is by custom a summons unrebutted stands. Therefore, one who attends court is presumed to accept a position either as a defendant, a juror, or a witness, and a jurisdiction. And you're basically the court has jurisdiction over you. Presumption. So attendance to court, for example, is just an invitation by summons. Unless the summons is rejected and returned with a copy of what we call a rejection filed prior to choosing to visit or attend, the jurisdiction and position as the accused and the existence of guilt will stand. So they make these presumptions about a person without even having met the person. I know your viewers are questioning, I mean, come on, what the hell? English common law, American law. What about the presumption that you're presumed to be innocent until proven guilty? Well, you see, the thing about presumptions is you have to rebut the presumption. And most of the time, these 12 presumptions were operation in court.
So who created these 12 presumptions? Let me see up here. I'm just showing it on the screen. So it's the Canon 3228, the 12 presumptions of court, the code of Canon Law. What is Canon Law?
Canon Law, it goes back to what we call the Christian ecclesiastical law, which one of the sources of the modern legal system goes back to ecclesiastical law, also known as the Canon Law. This goes back to the Vatican bringing in these ideas and these sort of legal formalities and traditions, Christian traditions that the Vatican brought out and made them into law through what we call papal bull, also known as the motu propria in Latin, which is on the volition of a pope. So when a pope makes a ruling or a judgment, they decide from now on, this is how it's going to be. So when the pope decides something, it turns into a legal principle in canon law, which over 1,000 years has been the most powerful form of law in Europe. And
so this is what stands in courts in Europe, and they actually take this into consideration, and they base everything on this canon law. It's to do with the system, right? I see. So basically, the fifth presumption you just explained about the summons. How I'm going to bring back the letter. So how's that related to the letter, to the fact that it's conditional acceptance of the summons?
So when somebody sends you a summons, what is the idea of a summons? Because the summons is not for you, the living fact. It's for your straw man, the fiction. Because you're presumed to be dead and lost at sea. You're essentially, the summons goes back to the idea of ecclesiastical law, summoning the dead. If you accept a court summons and you go and appear, and they ask, is the name in capital letters, Michael Bloom or Chad Manian, capital Mr., you're essentially acknowledging that position that you are the dead legal fiction. So it's like a spell to summon the dead. But when you send a notice of condition, first of all, it is a notice. I just want to make this very clear to people that a notice is not a letter. This is not a dear so-and-so type of a document. No, This is an official notice. When you give somebody a notice, you hand a notice or you serve a notice, you're essentially serving a legal and lawful document, which has a lot of legal validity as well in their system. So you're giving somebody a notice, and a notice of conditional acceptance is you are willing. You're not basically refusing outright or saying no. You're not saying yes. You're not saying no. You're making an offer that I am willing to accept the documents or correspondence you've sent to me. I'm willing to accept it subject to these following conditions. Now, when you make a counter offer and you state your conditions, what happens? A counter offer, in a way, is the beginning of a new form of correspondence that you're forcing them to accept.
Correspondence? Which, do you mean a contract as well?
Yeah, because when they send you something, in a way, it has the effect or the power of a contract. And when you go there, you're accepting the terms of that, giving consent. But when you send them your offer, you are rebutting by making a counter offer. That's exactly the point. So you're making them a counter offer. These are my conditions. And it's up to them to decide what they want. So you're giving the ball in their court. What do they want to do?
Okay, so let's continue with the letter. Notice to agent is notice to principal. Notice to principal is notice to agent. Is that of any importance?
Absolutely. When you're giving somebody notice, we say notice to principal and notice to agent because this is to do with something I call the principal-agent problem. It goes back to corporate law, company law, essentially. So when in the 1600s, in England, maritime law and the law of the high seas created a lot of the legalities which turned into the basis of modern statute law. So when people started to build ships and go on long voyages, what they would do is they would go and float a company. And when you float a company in the national exchange, essentially creating shareholding structure. You're creating 100 shares and you are becoming a shareholder, which is called limited liability. You're saying, this is my business, I came up with the idea, but I'm starting a company to minimize my liability. So in the modern idea of corporate governance, essentially, the shareholder is only liable or responsible up to the number of shares that they own. If I'm a minority shareholder, I'm not as responsible for what the company does. The company is a separate legal entity. It's given the power of an independent person, what we call incorporated entity, which means it is a body, a vessel with no soul. In essence, it is a non-living artificial person. It's a fiction rather than a fact. You are the fact because you're a living person, a living individual. But what you're doing is when you start a company, you are limiting your liability. You are saying, I am just an agent. My principal is the company that I work for. Even if you're a director, you're an agent of the company. You are acting in capacity of the agent.
So basically, it's to the directors and to the shareholders. That's what it's saying. And to the management, managing director and the employees or whatever.
Everyone involved in that chain of responsibility. You're basically saying to them, notice to agent as notice to principal. So whoever I am talking to, if I've informed this person, I have therefore informed the person that works for them, person that they work for. Notice to agent as notice to principal. I'm putting all of you, the institution and the employee, on notice.
Clear. So equity will not allow a statute to be used as a cloak for fraud. What on earth does that mean?
So in the law has essentially three elements. So LAW, which is land, air, and water. Land, the law of the land, is the law of the common man, which is common law, which deals mainly with the letters, the facts, and the substance, the content. Now, air symbolizes the principle of equity. Equity symbolizes the spirit of the law, spirit of justice, rather than the letter. Equity relates to the intent, your intention behind the words, rather than the actual structure of the way the words are spelt or the way the words are arranged. It actually takes into consideration the intention behind the words. and what you mean to say. Equity is about the meaning, the spirit. And the water, which is maritime, admiralty, and the statutes, which essentially, for you to be in commerce, you use the Uniform Commercial Code, which goes back to the Venetian bankers and the kind of maritime admiralty law. And you need all three. So the statutes, for example, maritime statutes, acts and bylaws, they're all about clarifying the application, giving more guidance. Statutes in the old days were created in order to allow judges to interpret the law with clarity, because in common law, case law takes too much time. You have to wait for a case to be tried and for a judgment by a jury to be made. Equity is, in essence, ensures that there's the spirit of fairness and justice. Equity completes the law. Without equity, there can be no law. That's the whole point. And equity goes back to what we call the principles of the equitable maxims. For example, equity will not allow the letter of the law to be used to do wrong to any man. Legislation harmful to man gives you lawful excuse.
I see. So so that's at the top of the letter, and then it's to Section 151 officer. Does that matter who that is? Or I guess that's who signed the summons.
So you're basically specifically pointing out the person who, according to the statutes or the acts that gave birth to the council. So there's something we call the Local Government Finance Act or something, I believe, which essentially laid out the basis on which all of the councils and making council tax payable and that sort of stuff. So it is the officer who was appointed and given that authority by the statutory law. So you're basically naming, or you're addressing it to the specific agent. That's basically what it means.
I see. Yeah. So we are in receipt of a letter summons which purports to have come from Cornwall Council and also Cornwall Magistrates Court in respect of the above account number and addressed to Mr. First Last and Mrs. First Last. Okay. I mean, I guess there's nothing much to add other than the Mrs. First Last is the fiction, isn't it? Because it's capital letters.
Yeah, the first name, the last name. I mean, so generally this is kind of template which people can then take on and use and customize and put their specific first name and last name. But when you're addressing it, so you're basically referring back to the specific correspondence that the council or the agent wrote to you on. And if they say summons to first Mr. So-and-so regarding this property or this address, so what you're saying is, I am referring back to your correspondence, which basically presumes to refer to the supposed fictional person. So you're basically stating to them, you're trying to create a bit of distance between the fact and the fiction, between the straw man and the living man.
I see. Okay. The summons is unsigned, which negates its legality, in brackets, Companies Act 2006, Section 44 and 45, and is accompanied by a notice headed with the logo of HM Courts and Tribunals Service, which is fraudulent under the Fraud Act 2006, Section 2(1), false representation, and Section 11, obtaining services dishonestly. The notice states that I must inform the council if I wish to make representation at the hearing. I therefore add this notice to you and the HM Courts and Tribunals Service. Wow. So what is he saying here? I mean, what is this Companies Act? Yeah, well, he's saying it's fraudulent. What have they done? They've basically, it's unsigned. Let's start with that.
So obviously, when you address a person and you address correspondence to somebody, the chances are that it is likely that there is one person writing to another person. So when you make a person-to-person address, so this is, again, all this aspect is saying is, it's got nothing to do with me, but it's to do with your laws, your acts, and your statutes by your own legalities, according to your statutes in the Companies Act. An unsigned document cannot be treated as a valid document. And again, this is exactly taken directly from the statutory, from the law itself, from the legal statute. So you're saying that you cannot accept an unsigned document because you are worried that it might be fraudulent.
And why do you think it's unsigned? You, Chad?
Well, personally, according to Halsbury's law, Lord Halsbury wrote this set of books on the administrative courts all being essentially fraudulent. They have no basis in law. So obviously, if you are being tried by pirate ships, essentially pirate vessels, they are not real courts. They are fake courts. And why would a fake company, some of these courts are actually themselves nothing more than companies, private companies. So if they are companies acting as courts, obviously they're committing an act of fraud. And therefore, if they are fraudulent in its very beginning, you don't expect them to sign anything. That's why a summons from them is utterly meaningless, because basically it will not have the wetting signature of a real judge.
Yeah,
it can't be treated as a legal document. That's exactly what in my opinion.
Okay.
If they did sign such a thing, they would be committing perjury. So obviously, one way or another. I'll give you a very funny example. I knew a guy, a friend of mine. He went into court once and he said something. This was a lower magistrate court, and he said to the judge, "Can you please recite for me? Tell me for the record, are you and can you please recite your oath for us all? If you don't know your oath, if you're not under oath and you cannot recite it, then you have essentially, declared that you have no authority or jurisdiction over me, which means you need to vacate. And you have no authority to try this case. I am the highest ranking officer in the court. And if you do recite your oath, I am going to arrest you for fraud and perjury." And so the judge left the room.
So that's checkmate.
Yeah, and then he came back after about 10 minutes, really upset, and says, "I declare that this meeting is hereby adjourned. I dismiss the case, but not because of the reasons you mentioned."
Really? So what's the point? Okay, so let's continue, because here he says that it's the letter he's saying is accompanied, and is accompanied by a notice headed with the logo of HM Courts and Tribunals Service, which is fraudulent. So what does that mean? So there's with the summons, there's also a notice with the logo of the courts, sent by the council. So is he saying, why are you the council? It's not your business to go and send logos of the courts. It's a different body.
So normally when the councils write to you and they claim that they're sending you legal papers or summons or whatever, it's essentially a form of fraud that they're committing, because if you are a council, you're just a council. Why are you acting on behalf of the court? So basically they're fraud by misrepresentation. So when you steal or use the logo of someone else, in a manner of speaking, you're committing a copyright theft. You're pretending you're stealing someone else's trademark, logo, and copyright, and you're misrepresenting yourself. So you're lying by pretending, it's in fact from a council. So you're basically calling out their scam. You're questioning their legality and validity. And absolutely, these days, most of the documents sent by them, which pretends to be official, notice from the court, is actually fraudulent. Because
I see.
They're not the court, so you know what I mean?
Okay, yeah, clear. And then he says, he basically says that obtaining the notice states that I must inform the council if I wish to make representation at the hearing. I therefore add this notice to you and the HM Courts and Tribunals Service. So basically he's saying, you are asking me whether I am going to show up if I'm going to basically take action accept your summons and literally walk to the court and actually attend the hearing. So that's what you want me to do in your summons. However, he's not saying I will or I won't. He just carries on going, I therefore add this notice to you and HM Courts and Tribunal Service. What does that mean?
So he's responding with a view of letting them know that if the HMS courts are also involved in this matter, I am applying this to them. So he's basically informing what we call informing all relevant parties who are involved in this matter. So although this matter has, in other words, something to do with the local council, which is essentially a private contract agreement between the resident or the tenant and the council, if they're going to take this matter to court and say that the court needs to get involved. So if you're basically taking up legal action, the council are not saying that they're suing you in court for breach of a contract. What they're actually, because none of us has ever signed a contract with the council. Where is the contract?
Yeah.
If there is one, there is none. It's to do with the fact that they're using the Local Government Finance Act to say that when you are resident at a place, you have to pay them. And, in a way, this whole thing is highly self-contradictory in a manner of speaking and highly confusing. So what you're saying is, if there should be any involvement of the court, you are letting them know as well in the same notice that basically I haven't got any idea of any wrongdoing on my side, that if you say that I've done something wrong, the burden of proof is on you who makes the allegation.
And if the courts are a part of it, then I'm also putting them on notice.
Absolutely.
I say, now, Cornwall Council have failed to respond to 3 notices and 1 affidavit, Exhibits A, B, C, and D. The unrebutted affidavit now stands as truth in commerce. S151 officer and Cornwall Council are now in default. The terms and conditions in the affidavit, Royal Mail signed for reference, blah, 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 are now in effect. So what is he talking about here?
So in this case, when somebody goes through the process of withdrawing themselves from the council tax, what they do is they follow a process. The first thing they do is what we call a DSAR, a Data Subject Access Request. So you're not just going to stop tomorrow. What this case has done is, in this case, the party here has written a DSAR, written a request to the council asking, I'm looking through my records, would you be able to provide me with more information? Since I am a tax-paying member of the residents and I've been doing it for all this time, I am obliged to ask these questions. Can you please provide me with the proof? I can't find the actual contract between you and me, which I signed. Can you please help me by providing the actual detail, if you have it on your record? Secondly, why you require me to continue paying this amount of money, blah, 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 when I feel in all these years I must have paid and I haven't received the appropriate service that I deserve. And asking them, which of course he didn't get any reply to. So the first notice.
So that's the affidavit, or these are the 3 notices?
No. One of the 3 notices is an affidavit. The first is a DSAR. The second notice is an actual notice that you have, after the first notice, you give 14 days. And if they don't reply, you send them a second notice and saying, since you have failed to respond to my first notice, I am offering you an opportunity. I'm giving you a chance. So this notice requires response. I need you to respond to the previous notice and address these facts. If not, I am basically letting you know that I wish to bring our agreement to an end. And the third notice will actually be the affidavit and the notice of default, that you haven't responded to any of my notices. Here is my sworn affidavit of truth. These are the facts. I'm offering you an opportunity to rebut my affidavit, which of course they failed to write to any of the 4 letters. So the 5th one, so they don't respond to any of his correspondence. They've just written him a very basic kind of template saying, your council tax is due, you haven't paid, I'm sending you, it's default, it's just a standard,
Yeah.
And based on that, you send the notice of conditional acceptance and you say, I am willing to, but since you have failed to do all of these, you haven't even responded to any of my correspondence, therefore you bring that matter to its light.
I see. Okay. And we do not give our consent to hearings being conducted in a court de facto and insist that this matter be dealt with in a court de jure under common law jurisdiction and that judgment be by way of a jury of our peers. So what's
Yes.
a de facto court and a court de jure?
So you basically have a default court, which is just a lower magistrate's court. They'll just look at it and they normally give what you call default judgment. So usually the council, most of the time, they don't even go through the whole process these days. They just say, well, according to a lower court, this person has failed to pay their council taxes. Therefore, they just look at it. This person, they stop paying their taxes. Therefore, here is the default judgment, and get the bailiff the right that you're in penalty, and they send you a fine. That's what you call a de facto court. There's just a standard, bog standard con-purpose sort of.
But he wants a court de jure, which is?
He wants an actual real court, which is a court of law, which basically has trial by jury. So he wants a real common law court, because a court without a jury in England is not really considered to be a real court of due process, according to an historical argument. One intellectual debate says that for you to have an actual court, you need to convene a trial by jury and follow the due process. And he's saying, if you're going to go to court, I want a real valid court of process with a jury, trial by jury. Otherwise, he's not going to ex facto judgment, because he's questioning the validity of a court without a jury. Essentially, that's what that statement really is, because you're bringing in the common law here.
Yeah, okay. And then he goes on saying, in reference to the summons, we conditionally accept to attend by special appearance only to the offer of summons, so long as the below points are honoured and answered in substance, point for point, and are provided a minimum of 7 days before the summons hearing. So obviously, what is special appearance? Very important, I guess.
So in a way, you're making a special appearance that if you, persona propria, you appear in person. So you're appearing. So these days, what many of the courts, I don't know if it's in Israel, but the UK and all the courts right now, you tend to have what you call blind trial. You have to attend. They give you a Zoom link or something, and in order to stop transmission of COVID, you have to attend online. And he says, forget all of that. I'm willing to actually take the risk and come there in person, make a full special appearance, appear as the person, not just as send your legal fiction and send your document, but you appear to attend the trial if my conditions are met. If court, I will attend, I will bother to do that. That's what he's essentially saying. So making an actual appearance in person. And if you're going to do that, also saying, I want an actual response, a valid response to my written correspondence, rather than just you, sending your papers to the court. Because, in a civilized nation, you have to follow what we call due process. Due process is, if a person is being accused of something or taken to court, by law, you need to send them all the correspondence, all the facts, all the evidence, and all the paperwork well in advance in order to prepare them for trial. Otherwise, you've created essentially the whole validity. An entire case can be thrown out in court for being invalid for that. Paperwork is important. So he's saying, if you fail to answer any of my former letters, why exactly are you even trying to write to me now? There's no basis for you to take me to court, which means there's no controversy.
I see. And he goes on, there's plenty more. So then he's saying, he's obviously talking about now his conditions. And what number one, proof of claim. Provide evidence of a valid contract between Cornwall Council or its members and first, middle, last, blah, blah, blah. That's basically his name, I guess, and his missus. Yeah. Showing offer, acceptance, consideration with wet signatures between all parties. So what's that?
So if you're saying that I failed to fulfill my end of the agreement to pay the taxes, and he's asking for an actual evidence, which is show me where's the proof of contract. So in law, it's called habeas corpus. So where is the actual body? Where is the evidence? So where's our contract? And secondly, if there is contract, you have to show, for a contract to exist, you need 4 things. So you have to have the parties to the contract. One has to make a valid offer. The second person must notify an acceptance of the offer. So there has to be an offer, there has to be acceptance, and there has to be what we call due consideration, which means you must have taken time to consider the terms and conditions of the offer, and then fourthly, consensus ad idem, which in Latin means a meeting of minds. We must have had a chance to completely understand each other's point of view and have the intention to create legal relations. And if somebody makes an offer, someone accepts the offer, they are legally bound because they've taken time to duly consider and they've got the intention to be bound in an agreement. Then you have a valid contract, and he's asking for proof of all of those stages.
And wet signature?
Otherwise, there's no contract.
It needs to
wet
actually...
signature, which is somebody must have signed. If there is a contract, where's the evidence? In the evidence of any contract, there's a signature. For example, if you go to a bank for a loan or a mortgage, you have their signature and they have your signature, and you sign in front of each other. There are lawyers, solicitors, somebody who witnesses it. You have to sign it, date it, and the wet ink signature, actually. So where is that? That's what he's saying.
Amazing. Yeah. So then he's saying, number 2, provide evidence Cornwall Council have given full disclosure as required by common law in relation to the services being offered, and that these have been accepted by us for the value stated. Well, it's pretty self-explanatory. Yeah.
Yes, absolutely.
Like basically, yeah. So what do you mean? Like garbage removal, cleaning of the streets. He wants basically to see where that's been agreed, that they've actually given full disclosure. What does that mean?
Absolutely. Full disclosure is important, because when you're about to, say for example, you've got a job offer, and before you sign a contract, they tell you, before you agree, you have to know that you'll be required to work from 9 to 5, Monday to Friday. You'll be required to work either physically on the campus or from home. We might require you to travel. That's full disclosure. I've told you what you need to know before you start, so that I am not tricking you. That's full disclosure. If you sign a contract and then, before you know it, I'm going to post you somewhere in, Mombasa, Mogadishu, in a different country, that's not full disclosure. So any contract which has denied complete information, no full disclosure, that also invalidates the agreement. And you have to give people the complete information. Otherwise, anything that they agree or sign is basically, invalid.
I see. So number 3, demonstrate manifestation of intent by way of our seal and or autograph on a contract between us.
Yeah, absolutely. Show me where I've signed. Where did I sign? Where did I agree?
Then number 4, provide evidence that the terms and conditions of any contract are lawful in common law, not statute law. Okay. Again, he keeps pushing to common law. He is only considering common law. Nothing else is valid as far as he's concerned, and he keeps stating it wherever he possibly can. And then 5, provide evidence that council tax is lawful. How do you do that? What would you
prove to me that council tax is lawful? Yes,
because it isn't.
Well, this is exactly what he's saying. So he's not actually saying that whether he believes it's lawful or not. He's not even entering into the argument. He's just saying, can you show me how and why you believe council tax? He's placing the onus on them. He's not making a statement, but he's asking a question.
So if I was to ask, let's say, prove to me that murder is lawful. So how would you do that?
Well, basically, this is the thing. If you're asking the government, so let's say a man is about to be hanged or sentenced to death, and his lawyer asks the government, can you please prove to me that what you're committing, which is murder, is actually lawful? Prove to me that murder is lawful. That's essentially the same thing. You are placing the onus on them to
I see. But I didn't mean that. I think I gave a bad example. I'm trying to see something which is obvious, which is very easy to prove that it's lawful. So if I was to ask what, which is easy to prove that it is lawful, like prove that Can you give me an example of something that is provable?
Well, for example, okay, right. So let's say, okay, paying rent, for instance, yes?
Yeah.
If you go somewhere, you need a place to stay, and the only place that's available is this place and you've chosen that because it's a little bit cheaper, and you've agreed, and they've asked you, this is how much it'll cost. So it's a little bit like, you're going to eat dinner, and you've seen something you like, and you've enjoyed your meal, and they've given you the bill. So essentially, it is lawful. You have to pay because, in essence, you had a chance to think about it. So you can't question the lawfulness of the bill, which you've already understood and undertaken that I am getting something.
So that would be the proof. If I was to ask, if I was to refuse to pay an owner of a restaurant, and my claim would be prove to me that it's lawful to expect me to pay, then he would say, okay, no problem. You came in, you sat down, you saw the menu, you saw the prices, you went through them, you asked our waiter to give you his opinion and advice, and then you considered it, and then you ordered, and you ate, and you swallowed, and you digested. Therefore, you need to pay. However, with council tax, there's no logical explanation like with paying a bill.
Whatsoever. Yeah, exactly. Why are you paying, and what are you paying for? Because, I'm going to break the news to you. The elephant in the room. Every single penny that the council tax has ever collected, do you know exactly where that money goes to?
No.
Have a guess, Michael.
It goes to pay subcontractors for keeping the city nice and clean.
I wish that were the case, but unfortunately, every single council in the whole country ultimately goes back to Citibank in New York, in America. A private bank in America collecting all of our council tax in England. Does that make sense to you?
How do you know that?
This is to do with a lot of friends of mine who've done the research, and essentially found it for themselves. There's a lot of information that it's actually being made publicly available. And yes, this is one of those which there is all of this information that is available publicly.
It's a scandal. We need to put an end to it.
Absolutely, because you see, the councils are essentially private. One of my friends, over the weekend, he put a slide up which basically showed one of the local county boroughs councils, where he looked at its actual management structure, its corporate structure, and he actually found the company registration. And it says there was a director that was appointed and who resigned on the same day. And if you look at the structure, the chain of ownership structure of the corporation, there are private companies that are owned by a private bank, which is headquartered somewhere else. So I don't. That puts the whole thing into question.
Everything's one big fraud. So number 6, Absolutely. To date, Cornwall Council has not complied with the Bills of Exchange Act 1882, which detail how a bill for a charge should be formulated. Provide evidence Cornwall Council does not have to adhere to Bills of Exchange Act 1882. What's that Bill of Exchange about?
So, for you to require payment from somebody, you need to send them a proper bill according to the Bills of Exchange Act. So, when they just send you threatening letters saying you haven't paid, you can legitimately reply, "Sorry, did you send me an actual bill? Send me a bill. Tell me exactly which services you provide and what is the cost of those services, and then I'm willing to pay. So send me a proper bill." That's what he's asking for. You didn't even send me a bill. How can you expect payment when no bill has been sent? That's, again, what we call a least. You have to send a legal pretext.
But don't they? Doesn't the council send a detailed bill? I think I got one when I was in London. Wasn't it detailed? I don't know. No, there was just an amount. It just says the month
on a piece of paper. Well, according to the Bills of Exchange Act, that's not a valid bill.
I see. Okay, cool. So number 7, provide evidence that a liability order is being sought against the legal fiction, persons, corporation, Mr. So-and-so and Mrs. So-and-so by Cornwall Council, a corporation, being of equal status as required by law and not against first of the family last man, first of the family last woman, or greater value, thus superior status. What? No idea what that is.
Okay,
To a corporation, which would render the proceedings unequal in law, thus invalid. I have no idea what that's talking about.
Okay, that language, essentially, what it's trying to get to is, let me see how I can simplify this. I mean, in a way, many of these notices that are written, it's written in a sort of similar fashion or style that gives the appearance that you're speaking to them in the same language. So usually when you go to court, they speak the language called legalese, which according to Black's Law Dictionary, it's not actually English. It's a dog Latin, which carries a totally different meaning. Now, he's writing basically as the living man to try and create separation from the straw man. And when you ask for a liability order, I mean, if you go back to the root of the term liability in Black's Law Dictionary, I mean, okay, let's talk about the occult art of word magic in law for just one moment. Liability, your ability to lie. Yeah?
Yeah.
So a liability order, in other words, they send an order to claim an amount from whoever is being held liable for either damages or liable for non-payment, or a liability order. When a debt collector comes to you with claiming he's got a liability order or something to seize property, so it's a judgment or an order that has to pass through a process, and he's asking, is such a thing even possible? Do you even have an actual real liability? Sometimes you can have a liability order, but the problem is it's gone to a stage where it's such a complete obvious scam, they're not even going to have a liability order.
Unbelievable. So that's number 7. Number 8, the summons has been made to the legal fiction of Mr. First Last and Mrs. First Last and noted in our initial correspondence, Exhibit A. We do not agree to the nom de jure, the legal fiction. We retain our inalienable right to stand as the man and woman. So is he saying here basically, anyway, you are asking a fiction to pay you and I ain't that fiction, so leave me alone?
Absolutely. He's saying if your dealing is with the straw man, not with me, in essence.
Yeah.
That's the ultimate point, yeah.
Okay. And then number 9, we attend by special limited appearance only. It's the second time he mentions that, special limited appearance, isn't it? Yeah.
So convene a proper court. And don't write to my, nom de jure. So don't write to my legal fiction or straw man. Write to me, the living person. Let me know what your matter is to do with me, and then I will appear in person if you have a valid claim or a matter to do with me.
And if they were to write to me, what will that be? How is that different? It's not going to be all capital Mr. M. Bloom. It would be what? Mr. Michael of the Bloom tribe?
Yes, it'll be in small letters, colon, Michael of the family of Bloom.
Okay. Now, number 9, we attend by number 10, our inalienable God-given rights. Inalienable means something that cannot be taken away, or something that I received when I was born.
Absolutely. So when you claim to stand, or you claim that you have rights and which have been breached under the Human Rights Act, essentially you are admitting that your rights were given to you by an act of statute. If you say no, none of that is of any relevance or substance to me because I have my inalienable rights, are also called the unalienable rights, which means that no lien of conversion, no lien can either give or take away what is naturally mine in common law as a sovereign being. That's what he's saying. He has certain absolute inalienable rights which are unaffected by anything.
Our inalienable God-given rights will not be subjugated and specifically upheld by written documents from the county court clerk and magistrate. It's like, who the hell are you to be talking to me? The Son of God, the flesh and blood. Go away.
Absolutely.
Okay. And then number 11, we hereby rebut all 12 presumptions of the Bar Association, Exhibit G.
There you go.
Isn't that a bit too presumptuous to rebut the presumptions?
Well, but here's the thing that everybody needs to do. You have to rebut all 12 presumptions. Therefore, they cannot use any of their game plan. So what you're doing is you're shutting the door and locking it before anybody even thinks of walking through that door.
But
so you're closing,
can you just rebut by saying I rebut? Don't you need to go through each one and say I rebut this because it doesn't make sense and because blah blah blah, and I rebut this because of this evidence, etc.?
Well, sure.
That's the exhibit. Exhibit G says all that.
Yeah. Yeah, exhibit.
I'd love to see that.
Exhibit G is the detailed, rebuttal of the 12 presumptions.
I see. Okay, we're not going to get into that because we're going to be here all night. So, 12, provide evidence that the correct due process of law has been followed in the issuing of this summons. Exhibit F. What's that?
So, to show that all the due process has been followed before. So in order for you to issue the summons, you first have to have gone through a process and highlighted why this person is being summoned. You can't just send somebody a summons. You have to send someone a notice of. There's several notices that need to be written to a person before you even go to the stage of summoning them. That's the point.
Okay.
And he's asking, can you show me proof that all of those processes have been followed?
I see. Obviously not. And 13.
Obviously not.
13 is similar. It is our understanding that according to observance of due process of law 1368 section 3, none shall be put to answer without due process of law, provide evidence, Cornwall Council and Bodmin Magistrates Court are not bound by this. So basically, because you didn't do due process properly, you are basically, I guess that you believe that you are above that and it doesn't have any power over you. So prove to me, where does it say that you are above that?
Exactly. Yes, absolutely. Because courts in this nation are bound by very strict, the rule of law has to apply. They have to follow what we call the due process. And courts themselves are what we call the subordinated institutions. They are subordinated institutions which are, like all corporate entities, they are what we call at the fifth tier. So you have what we call, if you look at it from the point of divine law or God's law, the creator, and then you have the natural living man, the sovereign individuals, and then you have the land that they live on, the law of the land. So the third tier, you have basically the governments and the assemblies of leaderships which are created by the sovereign man. And under the government, the state, those institutions, you have politicians and public servants, and then you have the institutions that they create in order to help them govern. So they are at the fifth tier, they are at the lowest level. So can you show me where me, who's a tier 2 sovereign living man, show me what standing you have as a fifth tier? You are slightly low. If you're here to serve the public, you are a public servant. If you accept me as a member of the public, you are my servant. I'm the public, you're the servant. Why is a servant talking to a master, essentially? That goes back to an old, I think, biblical idea, from the time of Moses, I believe.
Wow. But
no servant is greater than his master.
Yeah. Now, this is all stuff from 1368. That's a long time ago. That's like almost 1,000 years ago. Well, 700 years ago, 800 years ago.
Yes.
And it's all in this legislation.gov UK. It's all official stuff. I went there, I checked it. It's there. It's real. So anyway, there's this they took an excerpt here from it, and they're showing none shall be put to answer without due process of law. We're not going to go into this because it's too complicated, but we could carry on to the next one. 14, provide evidence the summons complies with the council tax regulations 1992 section 34 blah blah blah. So what's that? Application for liability order. That's something important as well. You want to talk about that?
So can you read that bit again for me?
Yes. So number 14, provide evidence the summons complies with the Council Tax Regulation 1992. And it's
So Council Tax Regulation 1992.
application
So
for
it
liability order. He's talking about that
Exactly.
application.
That's it. So without you don't just go straight to the process of sending summons. Before you apply to get a liability order, you've got to follow a set of steps. And he's asking for proof that they complied with that law. And again, it is highly doubtful if any council in today's day even know that they're bound to follow that. This is what he's challenging them on.
Yes, amazing. And then number 15, the court we attend is a common law court de jure with a jury of our peers, a court of record with a full transcript of everything discussed in the summons, provided in either written transcript form of our audio recording within 7 days of the summons date. We would not attend a fraudulent administrative court, as we would then be party to fraud.
That's probably the best, the bomb. Says he's willing to go to a real common law court. Now, here's something that I don't think has been made clear yet. So when we talk of common law courts, the High Court and the Court of Appeal, and in the old days, the highest, which is the House of Lords, these three were common law courts. And by the Royal Courts of Justice, they were all meant to be courts of common law. So the High Court, the King's Bench, Queen's Bench, is a common law court, and lower than that you have the Crown Court, and essentially Crown Court comes under the High Court. So if you go to a common law court, you can have trial by jury, essentially. So now, instead of the House of Lords, you have the Supreme Court, which is the highest court of the land. But mainly, in terms of the actual courts that people go to, it's either the High Court or the Court of Appeal, tend to be the two most frequently visited courts open to the public, generally. I mean, you can or Supreme Court as a member of the public, but not to go and do a case usually. But House of Lords, the Court of Appeal, and the High Court were common law courts. However, anything lower than that is what we call an administrative court. So magistrates' courts, county courts, these are all, administrative. And this letter is saying that he believes, or he's stating clearly that he will not address a fraudulent fake court, which means all administrative courts are essentially invalid. That's what he's saying. So take me to a proper court.
Yeah.
I mean, in most cases, nobody can afford to go. So this is basically what he's saying.
Okay. Are there any common law courts today?
I mean, the people are trying to set up, their own new common law courts, which is essentially trial by a grand jury. This is, something which is slowly coming back. There is a huge growth in this, and it's only a matter of time before it spreads like wildfire. And yes, there will be common law courts that will be sitting.
So common law is completely ignored by the man?
Absolutely.
I see. Okay. 16, we will be allowed to make our own video and audio recording. Okay, that's pretty self-explanatory. 17, evidence will only be allowed to be submitted by all parties with first-hand knowledge of the matter under oath and with penalty of perjury as per Perjury Act 1911. Very interesting.
Absolutely. He's saying that he will only attend a real court where people are sworn in and, to give testimonial through affidavits and this. He will not attend anything where, you're going to have a fiasco or a farce of paperwork and, solicitors do. So he's essentially saying he wants to appear as the common man, and he wants only those who have first-hand knowledge of the facts to come forward and testify and that sort of a thing. Which, again, because this is, the highest level or the most basic form of fraud, it's unlikely that any living person will be involved in this matter. So he's essentially just, calling their bluff.
I see. And number 18, evidence. So he wants them to show evidence that Section 78 of the Local Government Act 1888 does not apply to Cornwall Council. The Local Government Act 1888, which, what does that say? So it says 78 construction of acts referring to business transferred. Do you know what that means?
Business transferences, in this case, when you so this is more to do with, I believe, the state of debt collections and liability orders. So when they send the bailiff, they try and they take this liability order and then they kind of give it to a collection agency or a debt collector of some sort who claim that they are acting as bailiffs, whatever. Now, with a liability order, with any of this, usually there has to be like a deed of assignment or something where somebody has assigned someone to collect or recover a debt. Because that's not likely to happen in this case, you're not likely to get any sort of actual financial consequence as an outcome of this. This is the point. But also, in the Local Government Act, you have this idea of the construction of acts and statutes. And so again, he's referring to the idea that all of this that they're going to try and use to say that you have a legal duty to pay your council tax, he's essentially giving more argument to strengthen his case and invalidating the claim.
Okay. So 19, evidence that Section 79 of the Local Government Act 1888 does not apply to Cornwall Council. I guess it's the same thing, or part of the same thing. So we can move on to number 20. Provide the name and insurance details of the clerk of the court who authorized this summons and personally considered the claimant.
Yeah, this is a very important point. So,
yeah,
for you to satisfy the condition that you have followed due process in the law, the most important officer in a court is actually not the judge, but the court clerk is the one whose name should be on display outside the courts for you to see. He's the one that assigns the case to be heard in a court. So if they cannot provide you with the name of the court clerk, then essentially that court is invalid and that case has not been given due process.
Yeah.
This is something which I'm surprised if even lawyers knew about this, because it's not something that is talked about in today. It's not talked about very often today. Most people don't know that he's asking which court clerk actually assigned this case to be handled. That's what he's trying to refer to, because he already knows that it's impossible. No court clerk will have even been appointed. This has nothing to do with them for the summons. So essentially, he's once again invalidating their claim in another way.
And he's saying a similar thing in 21. Provide the name and insurance details of the justice of the peace who authorized this summons and personally considered the claimant.
Yes. So in a lower
but
court,
why insurance details? What? Why not his license number or something like that?
Well, I think in a way it's to do with the administration process. Usually this whole thing has to do with the financial infrastructure, which is to do with insurance, you see. So a lot of it is, okay, this is, again, highly debatable, highly controversial. I can't really say with complete confidence this is or isn't the case. This is just one debate that I've heard at some point, that the way the councils actually go about their business and getting people to pay council tax is essentially a form of insurance liability, basically. So they're trying to get a bit of money insured against, events when, councils, or rather, when these institutions get taken to court, they're trying to build a certain fund. There are insurance companies who invest heavily in owning these councils, according to one idea. I mean, I don't know about that. I can't really comment or say yes or no, but this is the reason why. Maybe this gentleman has done some research and he's found something that we don't really know. And he's saying, give me the insurance number, because when you go to court, there's something called the court fund, which is there's an insurance indemnity where that the insurance scheme is what makes the payout for all the mess ups that the courts make, and that's what he's asking for.
I see.
Because he's almost threatening them. That's the kind of veiled threat, because he's saying, if we go to court, I am going to sue you, and you will lose, and you're going to have to pay me from your insurance fund.
So show me that you're good for the money before I do business with you.
Yes.
Okay, so the same thing, provide the full name, that's 22. Insurance details and bar number of the magistrate who authorized this summons and personally considered the claimant. Number 23, the name of the man or woman who has created the summons, if it has not been created by the clerk of the court, justice of the peace, or magistrate. So what's the difference between justice of the peace and a magistrate?
I think they're slightly different.
It's like judges, basically, isn't it?
To an extent, yeah. It's to do with the type of power and the level of authority that they have.
Mm-hmm.
So the head of one court is actually called a magistrate. In another case, the official involved would tend to be a justice of the peace. But in any of the cases, the most important is still the court clerk, because you have to have either a court clerk or a justice of the peace or a magistrate who has issued or validated a summons or approved that a summons should be sent. So he's basically, again, questioning, tell me the name of the actual person who approved of this, because he knows for a fact that there's not going to be any of them.
Yeah, the living man, he says, or woman.
Yes, he was looking for the living man, yes, or woman, yeah.
Okay, now he's saying in number 24, provide evidence of that Section 135 of the County Courts Act 1984 would not apply to any man, woman, or corporation acting in contravention of by falsely pretending to act under authority of court. Contravention by falsely pretending. So who's pretending to act under authority of court?
Well, he's notifying them that if anybody is pretending to be a court, or is anybody acting under the assumed authority that only a court should have, he's letting them know that they're committing fraud.
And that basically says here, 135 penalty for falsely pretending to act under authority of court. Any person who delivers or causes to be delivered to any other person any paper falsely purporting to be a copy of any summons or other process of blah blah blah, knowing it to be false, or acts or professor to act under any false color or pretense of the process or authority of the county court, shall be guilty of an offense and shall for each offense be liable on conviction. So basically he's saying to them, you are breaking the law, you're pretending to be a court, and there's a whole section there's a law, an act that says that you shouldn't be doing this, and so prove that it doesn't affect you, because you're obviously pretending to be a court, which you're not.
Yeah, and you're not, and there's going to be penalties when your fraud goes public. That's what he's saying. He's threatening them that I know you're free, and I know that you are acting fraudulently, and these are the laws you've broken, and this is the potential penalty you're likely to face. That's it.
Oh yeah, imprisonment for a term not exceeding 7 years. I forgot to read that last bit.
That's my favorite part.
Yeah, shall be guilty of an offense and shall for each offense be liable on conviction, on indictment, to imprisonment for a term not exceeding 7 years. Wow. So number 25, provide the case number authorized by the court, magistrate, clerk of the court, or justice of the peace. That's simple. But they don't have it.
Exactly.
If only they had it.
Knows they don't. Yeah. Do you see the point here, Michael, is when you know the truth, no matter who you are, what your position or status is, once you have the power of the truth, you become utterly invincible when you know that your enemy is living on lies and they have no power over you. Simple.
It's amazing how lawyers don't know this stuff.
Well, yeah.
They don't, do they? I mean, no lawyer goes like, oh my God, this is one big scam. They're like within it. They're like they were trained. It's like doctors, who are trained to give medicine. These lawyers are trained to kind of support the fraudulent system, believing that they're doing the right thing, not even knowing that there's a wider perspective, that they're trapped within the smaller one.
Absolutely, because look, if you're a lawyer, you go to law school for 3-4 years, I believe, LLB and LLM course, whatever, and then you come out and then you have to do an apprenticeship to become a member of the bar, which is a fraternity, a private bar guild. Or you go and you become a solicitor, be part of the law society, and it's all about this little, small, tiny club that everything that you believe in, your whole profession, your whole occupation, your whole career and status depends on the legitimacy of this world you believe in. Because if this world that you've been trained to believe in is feeding you, you would never question it. Because if that system really works for you, why would you question it? This is the problem. And they're not trained to think outside that sort of framework. This is the issue.
Yes, exactly. Okay. Number 26, provide the official summons document with the official court seal and wet ink signature of the magistrate, clerk of the court, or justice of the peace who signed it. So there's no summons. So the actual summons that the council sent, they just created it, and they're not even a court. It's like me sending you a paper saying this is a summons, but who am I to summons you? I'm not a court, correct?
Exactly. Yeah. Sure.
And people
Absolutely.
normally get this nice fancy document that has the council on it and their logo, and it says summons, and you're like, oh, I'm being summoned. I better comply. Nobody even thinks that this is one big fraud. Unbelievable.
Yeah, absolutely.
Okay.
But again, critical thinking.
Yes. Provide evidence that Rule 18.2 of the Criminal Procedural Rules 2010 does not apply to the summons. And then the Criminal Procedural Rules 2010 says warrants must be signed. Simple. How come it took, only 10 years ago they came up with this rule?
Mm-hmm. That's right.
It's pretty recent. So every warrant under the Magistrates Court Act, blah, 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 must be signed by the justice issuing it, unless Rule 5 permitted. Okay, so obviously they don't have that. 28, provide evidence that Rule 7.4 of the Criminal Procedural Rules 2010 does not apply to the summons, the Criminal Procedural Rule. What does that say? Summons, warrant, and requisition.
Summons, warrants, and requisitions, yes.
The court may, what's that? Issue a withdraw a summons or warrant. A summons or requisition must contain notice of when and where the defendant is required to attend the court. Well, doesn't it state it on their fraudulent one?
Not sure.
Okay. So anyway, specify each offense in respect of which it is issued, and identify the person under whose authority it is issued. Okay.
That's right. Again, he's asking for more evidence of. He's basically playing them at their own game. So because they're conducting their affairs, they're pretending to be a court. So he's just calling them out and saying, if you're a court, I'm asking you to provide me with all of this, everything that you're accusing me of, give me X, Y, and Z. So all of that. Absolutely.
I see. Yeah. Number 29, provide evidence that recent case law does not apply to the issued summons. And that's Regina versus Bradford Justices. Okay, so that's like a case. It's like a what do you call it?
A ruling, a case ruling. Which again, if you rely on a case law, you're basically forcing. If they do decide to go to court at some point, he's basically saying that judicial precedent. This is the case that the judge is going to use to rely upon in making their decision. So he's referring to those cases in order to clarify the law to these people, to these fraudsters.
Exactly. Number 30, provide evidence of jurisdiction to deal with the matter. Seems simple. What's that?
Yeah. Do you have any jurisdiction? Yeah.
How do you prove that? What's their problem?
This is the thing. A real court or a real authority will have jurisdiction over a certain, area of landmass, really. So in law.
Okay. And then provide evidence of which jurisdiction the summons will be dealt with. Civil, criminal, other. Okay.
Exactly.
Provide, number 32, provide information of which rules will apply. CPR, civil procedure rules, criminal procedure rules, or other.
That's what he's asking for. So he's saying, I mean, generally speaking, going back to this point, so if you're based in, I think, Cornwall, and the council of Cornwall will probably be involved in the matter, and there'll probably be a court very close to that region which will have jurisdiction over you, either a lower, county magistrate's court or whatever. So it'll probably be a court close to that area which will be involved usually. But also he's asking then, in terms of the area of jurisdiction, is this going to be civil or a criminal matter? I mean, obviously he knows that this is just a civil matter, because when they say you've been sent a summons, you're breaking the law, it implies that there's a crime being committed. So he's asking them, is this a civil jurisdiction or a criminal jurisdiction or family court? What's the jurisdiction? Which court is involved? What's the jurisdiction? And what area, what type of law is it going to go into? The civil or criminal kind of?
It's like if somebody comes to and says, "Oh, I want you to give me blah blah blah," and you're saying, "You? Who the hell are you? Look at you! You're nothing. You don't have any power over me. Sod off, Look at you. Look at the way you're dressed. Look at the way you talk. Look at the way you walk. Bugger off. Go away." Absolutely. That's basically what he's doing to them.
Completely, yeah.
So, 33. Be it known, any attempt to hear our names in an administrative court setting that does not have a royal asset would be an act of treason according to the law, and we shall require the names of every entity involved for the leveling of charges.
Exactly. That's a really powerful statement, and it's a true statement,
Yes.
If a court does something incorrect, if a court denies a man justice, or if a court is complicit in just carriage of justice, it's committing an act of treason, the worst form. Yes.
Okay. 34. We will not allow a plea in our absence in any administration hearing, or allow a matter to be dealt with by any bulk handling center or any other place of business operating without a true judge under an oath, presiding over a court de jure with a trial by jury of 12 of our living peers in a court of record. Anyone entering a plea without written permission will be considered the defendant and will be responsible for all costs. Now, this is very interesting, especially the bulk handling, which relates to this phone call you sent me as well, which I didn't mention. You want to explain?
So, bulk handling, now, generally, for matters relating to a specific issue, for example, non-payment of council tax, it all goes together, and it's all treated by, let's say that there's a same office that deals with this kind of stuff. He's opposed to the idea of a default judgment or bulk handling, and he's saying if it's a matter specifically relating to him and his partner, wife, whatever, he wants to actually go to a valid court de jure, which is he'd rather attend a trial by a jury of 12. If it is a matter of importance worthy of going to court, then it can only be an actual court. So generally, sometimes, even in the administrative courts, they have what we call default judgments for council tax, collection of or non-payment of the local council tax. It's basically a bulk handling of
but what is that? What's bulk? Who's handling in bulk what?
I mean, the thing is, yes, there are various views on this. Simple answer is, I don't know how they do their business. I wouldn't be able to comment on.
But in that phone call, the guy called the courts, and he spoke to a lady, and he asked her, "Do you have a court number, a case number?" And she explained that they handle it in bulk. So what I thought is, let's say I owe there's a summons against me and against 50 other people in a certain county or whatever, and then they send the court those 50 outstanding bills or whatever, and then the court handles it in bulk. How do they handle it? What does that mean? They just go, what does the handling, what is the nature of the actual handling is? I don't understand. What does that mean?
I mean, this is the thing. None of us has actually managed to get to the bottom of that yet. Sorry.
I see.
And battery's a little bit low. Let me just quickly plug myself in.
Okay.
Sorry.
So we don't even know what that is. We know it exists, but we don't know what that is. Because the lady at the court admitted that there's only bulk handling and that she doesn't have his number of the caller. So there's no specific case outstanding at court against him. So and she admitted that the council are lying, basically, that they're committing fraud.
Absolutely. Now, the thing is, I've spoken to a few people about this bulk handling bit. I don't really understand who handles what. Is there like a call center that deals with all of this en masse? I mean, I don't know how they're going to do it, and it's very difficult for any of us to find out or get to the bottom of this. They're going to be, if it's a scam, that they're going to do everything they can to, be as mysterious about their ways as possible. But in his case, the phone call that this gentleman made to find out this information with the bulk handling, it actually tends to be most of the collection of council tax will seem to be handled in exactly the same manner. You won't have any specific judge appointed to handle this matter. You'll just have, this is what we call going to a default judgment.
Okay.
So there's no due process. You just get a default judgment. It's all handled together. All the people that don't pay council tax for that year in that area, they just get the same. I think it's for them a mechanical system. So it's a software that just sends out all of these letters to all of these people that your council tax are behind. I don't know. It's to do with the automation of all these processes.
Okay, so let's go through the rest very quickly because it's all kind of similar. And it's just ridiculous by this point. So at 35, if an account should ever be brought before any form of court, again, he's like saying this is not a court, nothing has actually been brought against anyone, but if you are to ever do that, we shall require it to be evidenced that due process of the law has been followed, for none shall be put to answer without due process of law. Blah, blah, blah. Clear. 36. If it should be evidenced that due process has not been followed, charges of misfeasance in a public office shall be filed amongst charges of fraud and fraud upon the court of all parties involved in such. What's this misfeasance thing?
So malfeasance of a public office is if any public official, for example, if it's a council or anyone involved in that, anybody who's in an official capacity performing a duty of office is involved in this kind of a manner in committing fraud. They're using the power and the office to do wrong. It's called malfeasance of a public office. So anyone who works for the council, any official who is complicit in this unlawful manner is essentially committing what we call the malfeasance of office. Yes, okay. That's what he's threatening them with.
Yeah. So 37, if any liability order is made against ourselves, the man and the woman, your actions will trigger a notification to you that the fee schedule enclosed will have commenced. The fees for servicing said order will be non-negotiable. Non-negotiable. So what does that mean? I mean, what is this fee schedule enclosed?
So he's basically sent them a fee schedule for inconveniencing him, for writing to him, for all of that. He's sending them, because they're sending him their fees, he's sending them his. For me to open your letter, it's going to cost me, it'll cost you £300 an hour, because my services are that costly. It takes me, for my time, taking my time to read your letter, I'm charging you £300. He's sending them his fee schedule. Yeah. So that's basically,
Yeah. I see. Any further attempts, that's number 38, any further attempts to contact must be made in writing and delivered by recorded delivery in a non-windowed envelope with a clearly marked physical return address, signed and identified by a living flesh and blood woman or man for liability purposes. Contractual documents cannot be signed by a corporation or legal fiction and must be signed by a real party of interest, not an unauthorized third party.
So he's saying that he wants an actual living person to sign a correspondence to him. He doesn't want to be dealing with non-corporeal, non-living entities. And he wants, because when they write to you, you see, they're going to write to you with one of these envelopes with the window addressed to the fiction, name in capital letters. And just another point I'd like to add, I just remembered it now. Writing to someone in capital letters, the capitis diminutio maxima, it's an ancient idea, and in Latin it's to do with the capitalization of a human being. To write into capital letters is the basis of the idea that you are capitalizing on a living flesh. You're turning that which is a living person. It's a form of black magic where you're trying to turn the living person into the straw man and turning that person into a monetary value. So that's the basis of capitalization. It's called securitization of debt. And he's basically warning them that I do not wish for you to write to me in one of these windows. Write to me as the living person, living man, and I want a letter signed by a living person to address me. If you have any matter to do with me, the fact, write to me the living fact. Don't write to my fiction. Yeah.
Fair enough. 39. Please note, we only accept legitimate communication through recognized official service processes such as the Postal Service. Any official communication must be sent through the Postal Service in accordance with the Universal Postal Union Convention 1929. No other forms of communication will be accepted. This includes any authorized or unauthorized bailiffs, any private corporations, any delivery services, private individuals, hand-delivered, electronic mail, SMS, WhatsApp, police service, court bailiffs, any private or public individuals or corporations hired by the court, any councils, or any other form of unwanted service. Okay. Yep, well, fine. That's clear. Please note, Exhibit E shows a transcript of an audio recording between first last administrator. That's the phone call I was referring to. The Magistrate's Court on the date 22nd of the 9th, 2021. Bodmin Magistrates Court, the Law Courts, blah, 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 where it is. This transcript clearly shows that Cornwall Council are acting outside of their jurisdiction, among other fraud, in the issuing of summons contradictory to Section 78 of the Local Government Act 1888. Please contact me if you require a digital copy of the audio recording. And that's basically the conversation where the court, the lady from the court, confirmed that they don't have anything on this guy, and that whoever is claiming that the court has actually issued a summons is not telling the truth, because there is no summons in the actual court.
That's right. Absolutely. So this is something, another common trick that many of the councils and many of the agents of state, that this is something that a lot of these private companies do. They send you this notice and they send you all of this threatening correspondence, claiming that you've been taken to court in this, but actually, it's not valid. And so if you just do what this guy's doing, stick to your guns and call them out and let them know that he's not willing to play their game and there'll be consequences, essentially you have nothing to worry about. Yeah.
Okay. And the next clause is just a repetition that they won't have, they don't want anybody to do a plea, with their absence, and basically anyone entering a plea without our written permission will be considered the defendant and will be responsible for all costs. So basically, you need us there. You can't go behind our backs and make decisions in our respect and expect us to actually comply. Not only that, we are going to sue you for doing it.
Yes, completely.
So, okay. Entrust that you, as Section 151 officer or Cornwall Council, after reading this notice, will change your previous decision and remove the unlawful charge that you have placed against us on our property registered with the land registry. The evidence of the council's fraudulent activity to achieve the charge notice will be provided in the future should this be necessary. Should you not be able to verify, confirm or deny providing evidence in substance to each and every of the above points, then we move the court and Cornwall Council to cease and desist from administrating our property without right, including any unverified future claims against us. Yours sincerely, autographed by blah blah blah. So they end it by saying that if you can't provide the above, then sod off.
Absolutely, that's a very simple statement. So we know that he's called our bluff completely well. So we know what you're doing is essentially wrong, unlawful. We know it's invalid. So from now on, I don't want to hear any more from you. And he's letting them know his position very clearly.
So what happened? This is pretty recent. Well, the result, you say, he got out of a £37,000 bill?
So there was essentially, well, he's not the only one. You see, there were several people who've become quite famous in the movement. One of them, of course, is this particular case, which we got out of paying a lot of money in council tax. But the second equally impressive case is a gentleman whose name I don't exactly recall at this time, but this was an actual powerful case that went to the High Court in the UK, and it went very high. It actually got into the common law court, so it went to the High Court, and the court, I'm trying to remember, was it the High Court or the Court of Appeal? They made a ruling which set a precedence, which now means that all the lower courts and the lower judges are bound by the doctrine of judicial precedence to follow as binding precedents. And he made a ruling that there is no legal duty in law to give the council your details. There's no duty in law to provide them with any information. So if there's no duty, so by extension, I mean, this is the most significant win for the living man in common law, because if you look at it this way, this is the rock that will create ripples throughout the pond and it'll make a huge impact. Because if there is no lawful legal duty to give the council any of your details, they can't come to you and ask for details, which means essentially you've blocked them and you've nullified every argument. If there's no duty for you to give them details, how are they going to collect their council tax from you? Simple.
Yeah.
So he beat them. So this was a major win against them. So it threw in, and I was reading the case actually, and one of the three Lord judges, one of the Lord Justices made the statement saying, it is, to my knowledge, possible for this case to create consequences upon all other future decisions and on a wide range of factors and matters involving the council and its taxes. However, in this case, the council, or in this case, this man was the appellant and the respondent was the council. And he said, the respondents, who we've given enough of an opportunity, have completely failed to prove that there is a legal duty to provide them with, the residents' details. So that was it. It was a humiliating blow for the councils.
Yeah.
So now people are not going to be afraid, and more people will stand up against them. And if people stop paying their council tax, this beast of a system gets starved, because, this monster can only exist because of our money. We pay this evil. We pay, for them to go and do all this sort of stuff. And when the common man, the living man, gets power over themselves and says no, when enough people stop paying them, they don't get their money, what are they going to do? See, this is how we win. We starve them out.
I see. Okay, so this letter we showed today is like a template, and anyone watching this in England and maybe in other countries, but definitely in England, could take this and just change it, and no matter what bill they get from the council, they could just use this, send it back to the council. No, but they need all the affidavits and all these other things that are mentioned here.
All the other elements, yes.
So how could they get that? Contact you?
Well, I mean, yes. So basically, we have our group. So there is actually a group on Telegram, which is mainly to do with information on the council tax and withdrawal and on common law. There's a great deal of information. So those in the UK know where to find us. There's a lot of information available for them. There's a lot of material that they can get hold of. And essentially, it's possible. But I think more important than that, it's just the idea of people starting to understand their own sovereignty. Yeah. I mean, although we're based in the UK at the moment, but this is significant across the world, you see, because everywhere in the world, people have to start waking up and realizing that, look, they're the people who have the power. The people always have the power. And it's the people who are giving away that power to any unlawful authority. You know, whether it's our friends, comrades in Israel or in America or everywhere, we're seeing two classes of society emerge. Those who are awake, waking up and standing up and fighting back, and those who are standing up as the living mind, body, and spirit. And then those who are happy to be enslaved by the system, to do as they're told, to believe everything that they're told, to be good little followers, you know, and never question. You can either live like a slave on your knees for the rest of your life, never asking any questions, never standing up for yourself, or you can slowly start to wake up and ask questions. Forget the matter of the council tax for just a moment. This message is very important for all of your viewers everywhere. It's not about just, you know, winning a small matter of the money against a council in England. It's about all of us, because listen, folks, we're all in this together, yeah? Every living man or woman who can hear my voice, hear this. It's about you. It's always been about you. It's about your freedom. It's about your mind, your body, your spirit, and your rights. Now is the time for you to stand up. Now is the time for you to take back the power. This is just one example of what is possible when you stand up in peace, honor, and strength and tell your truth. You have nothing to be afraid of. No matter what happens to you, what's the worst thing they can do to us? They may kill us, but they will not defeat us. That's the message I have for all of you, with all my heart.
Absolutely. Unbelievable. Wow. So what can I say? It's been an absolute pleasure. I enjoyed every moment. We went through this long letter, and I think, we really explained it in detail, and hopefully people are going to find value in it. And what can I say? Thank you very much, Chad Manian.
Thank
it's
you,
been
Michael.
a pleasure.
Pleasure.
Excellent. See you soon. And to our lovely viewers, stand up for your rights. We are all together in this. We have to do something. Otherwise, God forbid, what's going to happen. So thank you for watching, and goodbye.